Good morning, everyone. Today is September 5th, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project, originated by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great webinars. Rather, we ask people to contribute to a food bank if they like what they see and if they're able to contribute. Every week, one of my favorite parts of the program is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers since we began the series in the spring of 2020. Jean Lawler, would you please do the honors?
Hi, good morning, everyone. Good evening, good afternoon, wherever in the world you might be. The amount of donations of which we've been told so far, just amazing. $612,184.05. That's 6 million plus meals served around the world. So thank you so much for your generosity and for being here.
Amazing. Thank you, Jean, Natalie, all of our great speakers. Thank you all for contributing. Thank you very much. Today we have another great speaker, another fascinating presentation. Our special guest this week is Anne Marie Seibel. She's a partner in Bradley Arant Boult Cummings LLP in Birmingham, Alabama, and she's immediate past chair of the American Bar Association litigation section. She will present on the intriguing topic, mediation doesn't happen only at the mediator's office. We all know that often the success of mediation depends on the work done ahead of the mediation in preparation or after the mediation in follow-up. Those are the topics on which we will focus today. Anne Marie Seibel is a most distinguished lawyer. She enjoys pulling together the moving parts in multi-forum or multi-plaintiff high-stakes litigation. In these cases, she partners with her clients to approach the challenges of litigation in efficient and creative ways. For many years, she has used these skills to help a major facilitator of online travel reservations respond to cases across the country. In 2017, she served as lead trial counsel for this client in a 2-week trial, securing a defense judgment. The New Hampshire Supreme Court upheld this result after Anne Marie's argument before that court. In prior litigation, she played a central role advising Health South Corporation as it defended and prosecuted claims relating to a massive accounting fraud perpetrated against it by corporate officers. That litigation resulted in a $2.8 billion verdict against the company's former CEO and a $100 million settlement with the company's former investment bank. Anne Marie's practice has taken her to trial in venues as diverse as Alabama state and federal courts, New Hampshire state courts, AAA arbitrations, and the tribal court of the Porch Band of Creek Indians. Within the Bradley firm, Anne Marie is co-chair of the firm's Inclusion and Diversity Committee and former chair of the firm's Associate Committee. She has served the American Bar Association litigation section in a variety of leadership roles, most recently as chair of the section, a term which she just concluded just a few weeks ago, the ABA annual meeting, and she now assumes the most coveted title in any bar organization, immediate past chair. Anne Marie, we're delighted that you have time to share your thoughts with us today. Please tell us a little bit about the food bank to which you would like people to contribute if they're able, and then on with the presentation. The floor is yours.
Thank you, Jeff. Really appreciate the invitation to join today. I'd urge everyone to donate to the Community Food Bank of Central Alabama, and I believe Jean or Natalie was going to drop that in here. It is run by the CEO, Nicole Williams, who I've known for 20 plus years. So I know exactly how it's run. It's run a very tight ship. They have really done a great job of partnering with the community to both buy food, get food from grocery stores and restaurants, obviously do food drives as well. And then they say their number one request really is just funding, because for every dollar that they receive, they can serve 4 meals. So thank you for anyone who cares to contribute to that. And thank you for Natalie for coming up for this fabulous idea. And I've encouraged Jeff to make this a little bit of just back and forth. I'll give a little bit of background on why I wanted to talk about what happens outside of the mediation room. And, really because in my experience, that mediation day can often be a disappointment, or, you don't make as much progress. And often it's because of mistakes or lack of communication or lack of preparation to get there. And then on the other side, I've certainly been involved in a number of mediations where that day didn't work out, but because we left the mediation with agreements to talk again, and the mediator agreed to stay involved in some instances, the lawyers did it on their own, we were able to make progress as we move forward. So, I mean, the biggest thing that I have run into is that fear of clients of asking for mediation somewhere along the way because of sign of weakness. And so one thing in terms of preparation that I encourage clients, and as we build out scheduling orders to do, is to put in a time where mediation would take place, maybe something early and then something after discovery, so that the client doesn't have to make that decision that I'm going. You say, well, it's in the order. We've got to get ourselves ready. And then once you know that, maybe Jeff and I can talk about, some of the steps that you would take to get ready for the mediation to be sure that it is as successful as it possibly can be.
So
Jeff, I don't know if you want to ask a few questions, or I can pick some topics.
Oh, there's so much. Let's just start at the beginning, Anne Marie.
Okay.
So figuring out when is the right time to mediate. Yes, if a judge has ordered or encouraged you, and we all know there is no such thing as a suggestion from a federal judge, right? So that has to overcome some resistance. At the same time, just because someone has ordered you to go to a mediation doesn't mean you're going in the right frame of mind, in a spirit of making a deal. So let me ask you, both the long-term and immediately before mediation day, what do you do to help ensure that the client, both your side and the other side, will be coming to the mediation in the right frame of mind?
Well, I think one of the most important things is to be sure that from the very beginning, both sides are giving their client accurate description of strengths and weaknesses. I've certainly seen lawyers on both sides. I've seen, lawyers on my same side want to, say, we're going to win this no matter what. And that's how they're selling themselves to the client, is I'm the one who's going to win this case for you. And then you get to mediation. That's the first time the client has found out, oh, there's this defense that I didn't know wasn't really viable, or this was just a theory. So I think one of the most important things is it shouldn't be just in the mediation prep session with your client where you're starting to say, here are some of our weaknesses. And you certainly don't want the mediator to be the first one to walk into the room and say, well, have you thought of these 5 weaknesses as your counsel explained it to you? So I think it's critical that going into the mediation from the, all the case assessments leading up, even if it happens 3 years into the case, that the client can look back and say, all right, well, Anne Marie told me about this at the outset. This was a risk that we had. I'm not surprised by it. Because if they're surprised, then they lose trust in their counsel, and then you've lost your ability to have a successful mediation in and of itself.
So sometimes, do you find that there's a mismatch between the factual or legal state of the record and the emotional state of the client? And how do you, I see by that smile that we've all been there. Tell us how you cope with those kinds of challenges?
I think it comes in different ways. And the way I typically see it is that the lawyers, maybe even the lawyers on both sides, know that it is a case that should be settled. Let's say it's a contract dispute that has a certain value that we can all probably guess at the beginning, and it's going to be very expensive to litigate. But you have business folks on both sides who are emotionally attached to their position, or they had some bad blood between them, and that's the discussion I find myself having most often, is to say, I know that you want to litigate this, and you're telling me right now that you will pay whatever it takes to litigate this. But I've also been through this enough times to know that you're not going to like what that total is at the end of how expensive this is going to be. And I know you don't understand why it's going to be expensive, because you think it's a simple dispute and it can't be that hard to produce documents and do depositions. But to walk the business person through, let me walk through for you the litigation costs, like actual fees, and then the time of your employees. Are you sure? I'm happy to defend this all the way to the end. We can do this. That's why, it's better for me. And I'll often say that it's better for me to get paid. So we can do this. But do you want to take your CFO out and sit with me for all the sessions that it's going to take to prep that CFO for a deposition? Are you sure that you want to stop your IT department from doing their security checks to pull documents for me? And to kind of bring them back to, get their non-emotional business side thinking about, oh, from a business perspective, maybe I need to settle. So that's the most often discussion that I have, sort of with the emotional discussion. I've also seen things happen in mediation where the other side says something that's factually inaccurate or that is seen as an overreach, and the temper will heat up in that to say, well, now I'll never settle with these people. Like, they're playing games. And for that, sometimes it takes walking away, letting everyone have cooler heads prevail, and coordinating back with the mediator to say, can we, have another session once I get everyone's temperature back down.
So let's back up just a little bit. You're dealing with large business entities, corporations, or other perhaps multinational businesses. Do you find yourself performing a quasi-mediation function between perhaps different factions, sales and engineering, or legal and the business unit? Do you find yourself mediating between different groups as you prepare for the mediation as to what will be the position of the entity or the company?
I think that's a really good way of describing it. I think the answer to that is yes, in terms of, sometimes the in-house legal counsel. Most of the time I'm working with companies that have an in-house legal department, but sometimes their loyalties are a little bit spread thin too, right? I mean, they have a business executive that they're reporting to every day, where I'm just the outside lawyer. So sometimes I can say things to the business executive that the in-house counsel is unwilling to say to their boss, because they have a different relationship that they need to do. So that's where it will come up, where the in-house counsel is saying, let's go. And that's where I'm saying, okay, I get it, but let me just explain to you the practicalities of what is happening here. And I think it happens with, especially litigation, where there are multiple different lawsuits, and so the individual cases may affect the next one, to sit back and say, let's talk about the reverse strategy. I've been in litigation as well, where we said, we have to try them. So we are going to have to put your executives through depositions. I need you to invest what it's going to take, because we have to try these, because if we settle one, it'll cause the next 12 to settle, and we don't want to get into that position as well.
So let's assume that you're going ahead with a mediation, whether it's voluntary, court ordered, or whatever, and you undertake to prepare with the mediator for the mediation. You want the mediator to help you as much as possible, understanding the mediator is there to help everybody as much as possible. So how do you initiate your communication with the mediator? Do you typically contact the mediator regarding, hey, let's schedule a date for mediation? Is it a member of your staff who does that? What's the very first point of contact with the mediator?
I guess it depends on where it's been generated. I have certainly had state court judges who have told me which mediator to use. So that's pretty easy. You just say, we've been referred again to your offices. That is often not very promising when I hear that that's what we're about to undertake. But otherwise, I do think it may not be that I'm making the call myself. It depends on what relationship I have with that mediator. A lot of times I'm working with local counsel, and so we are trying to find someone in a local jurisdiction, and it'll be local counsel's role to make that call because they have been a repeat presenter in front of the mediator. So often I'm coming in as a completely unknown entity because I'm national counsel and I'm just dropping in, and that mediator knows my local counsel well, but doesn't know whether to trust me at all. So I'll start the communications with local counsel to find out time. I'll say one of the biggest challenges we've had is, in a lot of jurisdictions, very good mediators are very, very busy. And trying to get a date on the calendar can often put things off 2 to 3 months, which then obviously the dynamic of the case can change in the interim before you get there. But my preference is to find a mediator who is willing to do sessions with each side before we get to mediation. But I mean, not everyone takes that. I've found that really helps us be in the mindset of trying to get a deal done if that's our intent.
What do those preparatory sessions look like?
So let me back up a little bit too, just and talk about some of the timing leading up to mediation. So another mistake that people make is thinking we're going to mediate, October 10th, and they're going to tell their client October 7th what the recommendation is or what their settlement recommendation is. Really being sure how much time the client needs. If there's insurers involved, obviously you need to add in more time, and work backwards from that to say, this is when we would be ready to talk to the mediator if the mediator is willing to have a pre-session. So you really have to have enough time for them to get the recommendation, to get authority internally, and ideally have that authority before you go into the pre-session, so whether you think you're going to be very far apart. Really good mediators, in my experience, by that point have read our position statements, whether they're shared or not, have questions for us, and then allow us to provide, here's where we think the other side is coming from, particularly if we know the other side might be playing games or that we've seen them before in mediation. We know that they have a certain method that they like to use, to give the mediator a heads up about that. Because when we haven't done that, you're dealing with someone on the other side who's going to come in 3 times of what the real number could possibly be and just mediate down. I was in one mediation where the mediator said, well, they're just negotiating. And he said, well, they're not just negotiating. We've seen them do this 7 times before. But he spent hours with the mediator trying to explain they really do this all the time. The pre-session allows you to cut to the chase a little bit faster at the mediation, to say, here's what I know about my case. Here's some things you, mediator, need to know about the client. For that pre-mediation, often it's not with the client, which allows you to talk bluntly about, here's who's coming for me, here's going to be their limits on their authority, here's what they know about the case, here's where I may need your help, mediator, in talking to them. That's what I found really helpful. And then, I really have been even in mediations where the position statements have had gaps in the numbers going in that we think we can close before we get there to make the first offers more productive, and have had mediators help say, well, okay, I understand you think they have made a mistake in their calculation. Let me go back to them now and see if they can give you updated paperwork before the mediation, so we're dealing with real numbers and not inflated ones.
So these are typically just between the lawyers and the mediator, and I assume you're doing this not with the lawyer from the other side, but it's a private conversation between you and your team and the mediator.
Exactly.
And you're discussing things that you might be, shall we say, cautious about putting in writing about
Yes.
mood and temperament and personality of your own client?
Yes, I think mood, temperament, personality of my own client, and maybe the same about the judge, right? Things that you would never put in writing about whatever tribunal you're in front of. That's also a good place to talk about. We know that this judge is going to rule against us. We get it, but we're willing to take it on appeal, but that's going to be expensive. So this is why I'm getting to this recommendation, or this is where our position is. Things that you would not want in a position statement, and certainly not in a position statement that you're sharing with the other side.
Right. Let's back up a little bit.
Mhm.
And you mentioned those cases where you may be national coordinating counsel and you have local counsel in a faraway jurisdiction, and you're going to be guided more or less by their recommendations as to who the mediator should be. And there are other times where you may have more of an input into that.
Mhm.
So let's ask, in terms of preparing for the mediation, what is the due diligence you do on mediators? Every mediator loves to know about this
Right.
sort of thing. How do you go about picking a mediator?
Well, it's the typical send it around the firm, which all mediators know happens, and say, has anyone appeared in front of this mediator? I'm trying to be much more conscious of the fact that we need to have more diversity in who we're appearing in front of too. So I know that the ABA's Women in Dispute Resolution, for example, has a list of female mediators. So I've used that before to look at as well, to kind of force people to think outside of the box. And then you know, get a feel for what types of cases and what their approach is. I had one really challenging case that we were trying to mediate early while we were in a tolling agreement. I knew that there was a complicated business deal that might be the way out, and we worked hard to find a mediator who had that business acumen to help put the business folks together during that day. Or, that was something that they were known for. I've also had, really small cases where what you needed was someone that was very familiar with the local jurisdiction, who knew the judges well, who was sort of folksy, because that was the plaintiffs and even the defense on that case needed that kind of hand holding for the mediation, and you look for something different in that regard. And then, really big ones. That one you mentioned, that was a very large settlement with stacks of insurers on the other side. You needed someone that was familiar with how to get, through all of that noise. You can't go to someone who's been doing small cases if you have stacks of insurance on the other side. You need someone who's lived that.
So you send emails around the firm. That's the first thing that you do. And how much in those inquiries, how much do you focus on, say, has the person done construction defect cases involving dams, right?
Right.
That's one way to do it. Another, at the other end of the spectrum, might be have a personality, a person who's whatever you're comfortable putting in writing, say, very sensitive personality, takes this matter very personally, easy to get, easy to press his button when we talk about his or her button when we talk about certain things involving the case. And you really, so we've got case specific things and personality kinds of things. What kinds of inquiries do you make when you put those emails out?
I think a little bit of both. Definitely in I was trying to think, arbitration context, you're looking for specialty in an area. In my experience for mediator, I'm looking more for who gets it done, right? There are mediators who aren't going to push beyond where the parties are comfortable. But if you know that you have parties on both sides that you think the case should be settled, you really think it should be settled, and you need help, then it's who is willing to put in that pre-work, who is really good about coming in and talking to you, not just about what's your next move, but I've studied this. Here's where your weaknesses are. Now tell me your next move. Who's really skilled at that piece. I think it's, and then as I said, I've had my hand forced a few times where I don't have the choice in the mediator, and it's just the mediator who is the judge's pick. That, as I said, you don't get much success, I have found, in that, if it's just the judges going back to the same mediator, as a friend. And then you've got to be careful because you think the information is getting back to the judge, which I've also had that experience where you're pretty sure that whoever your mediator is going to report back to the judge on how the parties acted. And it could be good or bad.
Yeah, yes,
it may be out of your control.
So yeah, yeah, that'll be the topic for the next interview we do together, Anne Marie, because there's a lot of ethical as well as practical issues there, both for neutrals and for advocates. Let me ask you, when you want to get a sense of whether the mediator knows how to close the deals, that's what you were talking about. What do? You ask others in the firm whether the mediator has done that in situations with them. I assume that's one thing that you do. Do you ever call the mediators to try to get a sense of their personality, whether they'd be able to get on wavelength, both with you, your client, and the folks on the other side?
I've done the latter. For that one case I'm thinking about that was early. It was early. We're in tolling. It was very, very heated. I did call a couple of mediators and explain what the situation was. And I think we traded mediator names in that case, where we each had a few. And I can't remember now how we finally got down to the one we used, who ended up being exceptional and did get the deal done. But you did say, oh, what do you do? I mean, here I am. It's extremely heated. I know there's a business deal that should be at the end of this. They don't see that yet. What are your methods? Do you ever take the business parties, out and talk to them separately? So I think I have done that. I've also done it. I think we've interviewed mediators in jurisdictions where we were looking for knowledge of the judge, right? That we were going into a case. We obviously had local counsel. We knew what they thought of the judge. They knew what their likely result was, but we needed someone else to talk to the client and say, I've seen the judge handle this type of case 100 times. This is what they're going to do on summary judgment, or they're going to deny summary judgment. They always deny summary judgment. Sometimes it's important to get that through to a client's head of, you're going to have to go past that. And so I can think of a couple situations where we had local counsel poll locally beyond their own firm to say, who is the best mediator who knows this judge, but doesn't know them so closely that everything's going to get back to them and can help us get the deal done.
Okay. And when you're trying to suss out a mediator's skills, let's start with that. How do you think of a mediator's skills? What are the skills that a mediator needs to bring to bear, for which you're looking when you're doing your due diligence on a mediator?
I think the number one thing is preparation. I've seen a wide variety of, we put all these hours into a position statement, and there's a big difference of walking in where someone has read it, has found a case that's wrong or something, has questions for us, as opposed to someone who is so busy that they've read the position statements that morning and they're just going to, it's just the next thing on their list, just like. So preparation to me is the most important part of saying, I'm willing to, take the downtime in the mediation I have the prior week. Let's get on the phone at 1 o'clock. Let's talk through it. Let me ask you questions. I mean, and it puts the lawyer's on their best behavior if the mediator ahead of time sets those expectations high, because you also see lawyers just wander into a mediation and they haven't really prepared and they're just like, I'm just going through the paces. So the preparation of the mediator, I think, is the number one thing. And then this is harder to figure out if you don't have enough repeat experience, but just, is the mediator just shuttling, or is the experience that the mediator comes in, spends 30 minutes in that room, really talks through the issues, walks through a couple different options and helps you get to the next move? Or is their only role, I'm just showing up, I just want your next number, I'm going to bring it to the other side? Something that the lawyers could do themselves.
So when you're trying to find out whether the mediator works hard before the mediation to prepare, I assume you cannot just say to a mediator, by the way, are you lazy? That's not very likely to get much of an answer. How do you determine whether the mediator does have that kind of conscientiousness?
Often you can tell it by their website or the pre-mediation materials that they may send you when you reach out to schedule, that someone will say, okay, here's my procedures. You're going to get me a position statement by this date. We're going to have a pre-session on this date. It gives you the idea that they're, going to be prepared and work. And then it's also just asking questions of other people of what has happened in their situations. And you've got to be careful about that, because every case is different and there's emotional and factual issues that are happening that may have someone not having good experience in the media. They think that experience was with the mediator, but it was just with their case. So you've got to take that all with a grain of salt too. I mean, that's why you try to get as many different opinions as you can.
Yes, I think psychologists call that attribution theory, don't they?
Yes.
You see someone behave a certain way in one circumstance, and you think that's how they are. Whereas with yourself, if you fall short or have a problem, when you judge yourself, it's always a matter of the circumstances, not a matter of how you are. So yes, I agree. It's important to get multiple data points when you're trying to figure out how a mediator, quote unquote, is. So once you've selected a mediator, as you say, you get some information from the mediator. Please have a position statement or brief, whatever it's called in the particular area, to me by thus and so date. Then we'll schedule a time to talk to each other once I've gotten the mediation brief or statement. So let's talk about those mediation briefs or statements. All right, do you have some general rules as to what's effective and what's not effective, or what's appropriate and not appropriate when you prepare a mediation brief?
Well, I think you've got to make it just long enough that brings the mediator up to speed, but not so long that they're never going to read it all, right? I mean, the lawyers are so deep in some of the details of the case. You've got to resist the temptation to just regurgitate your briefing in front of the court with extensive footnotes and things like that. I've seen people tempted to say, we've got to tell our entire story and we filed a 100-page summary judgment and we should attach that for the mediator. I mean, the mediator doesn't have time to do that. I generally find that it is helpful to have the piece that is exchanged with the other side and the piece that is just for mediator's eyes only. That it is generally useful. There are certain things that you want to tell the other side about your willingness to be there to mediate. You're there in good faith, but you have these 5 issues that I want to tell you. And then to have a piece with the mediator to say, and we recognize that we're in a jurisdiction where we're unlikely to get summary judgment. So we get it, but here's where we think our best position. So I like having a piece, even if it's just a cover letter. That's the cover letter to the mediator saying this is our attorney's eyes or the mediator's eyes only piece, and then having a piece that the other side can see. If there's numbers at issue, I've been in some litigation where it's not just pain and suffering, but there's a calculation you can do to get to the number that you're fighting about, that I want that exchanged for sure. And and a couple times we've had that happen where the other side's number suddenly has a new, penalty or something added in. Having that exchange ahead of time has allowed us to say, okay, we have a problem here. Now let's go study that, as opposed to finding out the morning of mediation.
So what about dealing with weaknesses? There's some conventional wisdom that mediation is a place for total candor and talking about the weaknesses as well as the strengths of your case. How do you deal with that in the run-up to the mediation, either in the briefing or in the preparation calls?
I mean, I generally think you've got to acknowledge that with a smart mediator, because if you don't, you lose credibility with the mediator. I mean, my goal is to have that mediator trust what I'm saying 100%. So when I want them to push the other side, we've built up that trust and they say, okay, I know which side is telling me the truth, so I can push the other side a little bit more to get to the middle. And you've got to be careful, because that's where the client may not want you to expose those weaknesses as much as you think may be necessary to earn the trust of the mediator. But I think flagging it is important to say, whether it's, I'm in a bad jurisdiction, or, what I've not done as much is reveal if I have a bad witness, right? Unless it's obvious from some deposition transcript that's already had. If I know internally I'm not going to be able to tell this story, I may not reveal that yet to the mediator. But if there's a issue of law that we're running up against, I would reveal that, because my main goal, and that's my main goal in front of judges and mediators, is by the end of the session, I want them to trust me more than the other side, because if it didn't settle, then at least I get that next phone call that says, all right, Anne Marie, what do you think? Should we go back to them? Or is your client ready to make another offer? Or do you think I can get something from them? That, where a mediation has failed and I've built up trust with the mediator during the mediation, is where I've had the most success after the mediation of keeping that mediator engaged and maybe getting to resolution.
Okay, so then in terms of giving the mediator a taste of the client's personality, do you ever include the clients in any pre-mediation communications, either at the point of selection or the point of preparation, to make sure that the mediator is indeed going to be able to get on wavelength and have some chemistry with your client? Or does that just happen on the mediation day?
The client is definitely involved as we're choosing the mediator. So I mean that we may say these are the 3 that have been recommended in X jurisdiction. We're recommending this one because of, sometimes it's these 3 have been recommended and we're recommending number A because we can get in the time that we want to. Sometimes because we think they have the longest, best knowledge of the judge. I cannot think of a session where I've had the client on the pre-mediation piece. And that can be, but I have certainly, after the pre-mediation session, given my client an expectation of what the mediator said, right? That I want them to know, all right, I think this mediator is going to want to know all of our weaknesses. Like, they're fully prepared. They've read everything. They're going to have read every case that's in here. So be ready for us to get tough questions. I want them to know that before we walk in. Or if I think we have a mediator who I don't think is going to be that active, to say, okay, it's going to be up to us to really push the day along if you want to get this settled. So you might have to be more flexible. So I try to give you the mediator preparation for what the setting is going to be. And one piece of that is just what to expect that day, right? Are you going to have an opening session, or you're going to have to see the other side? How are we going to be set up? I've definitely had clients nervous about, am I going to have to sit through that opening session? Often clients do not want that.
And that's an interesting piece of preparation. How do you deal with that?
I think it depends. it's one of those things I've had mediators ask, do you need an opening session? I would say in most cases you don't, at least not in these business disputes. If people kind of know who the characters are, it just gets everyone heated because the lawyers feel like they need to present and be lawyerly, as opposed to what you're really trying to do, the mediation, is get things resolved. But if there's going to be one, I want the client to know that ahead of time. I mean, we have had ones where there's, I can remember one where the plaintiffs brought 11 different representatives on the other side, and there we were on our defense side. And it was sort of intimidating and exhausting for the client to look at all of this. And then also to say, how are they going to do anything in their room? They have 11 people over there. Like, this isn't going to work. I'd almost rather that we hadn't known that. But I do want the client to be prepared. Basically, like, you don't need to say anything. Just let the lawyer, let the mediator set the stage, let the lawyers say what they need to do. Very, very rarely have I had the mediator ask, does your client want to make a statement to the other side? And I can only think of maybe one case where that happened, where it was, I think it was a water dispute, and someone wanted to present that we didn't mean to do anything wrong. We're here to resolve it. I want you to know that at the front of, start of the day. And the mediator asked for the client to say that so that the other side heard, in sort of good faith, we're all here, and not get past the lawyers.
Do you find that mediators in those pre-calls, when talking about the need for a joint session or not, are proactive in terms of describing what the agenda might be for such a joint session, or what the time limit might be, or limit on the subject, so that you can perhaps have a conversation on the issue where the rubber hits the road, but not allow lawyers to do a lot of grandstanding and showboating?
I have had, more commonly, the question just comes, do you need a joint session?
Uh-huh.
Do you all see any reason to have one? And then once you've had one, I think I have seen people say, well, there's going to be no more than 15 minutes per side, introductions in 15 minutes. You've got to put a time limit on that opening session, or you've guaranteed yourself a mediation that's going to go on late into the night. Because it takes a little while to get everyone's energy back down or emotionally from the joint session, no matter how well run it is. You've seen who the other side is, and people's backs are up.
Mm-hmm. Okay. There are many interesting ways to deal with that. We may have time to get into them. Another subject I wanted to discuss in terms of preparation is talking about dollars and cents. And that there's a kind of a tension between wanting to go in with an understanding. You're almost always on the defense side, as I understand it. Having an understanding of what your top dollar is, having preparation on that, and yet having some flexibility, because after all, you come to the mediation, among other reasons, to learn things.
Right.
And you may learn some things either from interactions with the mediator, interactions with the other side, interactions with your own client, whatever, that may make you think to yourself, maybe we don't have the right top dollar here. Maybe we shouldn't be so generous, or maybe we need to be more generous. How do you balance that tension between being prepared and yet maintaining flexibility as you go into the mediation?
I think if possible, from the very beginning, talking in ranges with the client is helpful. And also, the way I've often approached it is very practically to say, here's where we think the exposure is. Here's where I think our chances are. Here are your defense costs. Let's come out with a number that makes sense, which gives you some flexibility in the mediation. If you find out all of a sudden information that goes from a 50-50 shot to you have an 80% shot of winning, that you say, all right, now we have a construct. We didn't just pull the number out of the air. It doesn't work for all cases, obviously, but if it gives the client something to hold on to say, I understand how you're getting to this number based on risk, and then we can change it as we go. I think it's harder, internally at some clients to get their, sometimes they're given a range, and sometimes their internal operations say, this is your number. And, there's no flexibility because the levels of approval are so high. I've been in mediations where my co-counsel didn't know what their client's authority was. I've thankfully been in situations where my client has been pretty forthcoming with me about what their authority is, but there are clients who do not tell their lawyers what the authority is. And so the lawyer is flying blind and the client's holding on to that to make their own assessment as you go in. So I think you're right. I mean, you've got to be flexible. You also need to think a little bit with your client ahead of time about what your first offer will be, so that you aren't doing that in your first session. Ideally, particularly if you're working with other defendants, you have a good feel ahead of time of this is where we want to start, so that that first hour isn't spent with everyone arguing about where to start.
So when you have multiple defendants, that changes the preparation calculus
Yes.
altogether, doesn't it? Why don't you talk about some strategies for success where there may be multiple defendants and the disputes as between them may be as intense as the disputes with the plaintiffs?
Yeah, I mean, there it gets pretty complicated, and who's in what room? Are you all in the same room? You need to be divided up. Are the disputes such that you can't all sit together, or you work as one? There it just takes more pre-planning. It depends on how good your relationship is with those other defendants, and if it's adversarial. I mean, if it is that you truly have a united front, then there are ways of going into the mediation ahead of time and saying, we're all making joint offers, we're all moving at these percentages throughout the day. If you are fighting amongst yourselves, then you need to know that, and your client needs to know it ahead of time as well, so that you have the ability to plan for it. That's where you need, I mean, then you go back to your question about how you find the right mediator. Then you do need to find a mediator who very often is in more than two-party disputes, who is very comfortable shuttling from room to room and dealing with what's happening on the defense side. Or I've seen it on the plaintiff side too, where there's multiple plaintiffs and they can't agree on how they value the case. And so you're getting demands that don't make any sense.
And I imagine, as always, you want to be the one who, in the mediator's eyes, is most trustworthy, so that when the mediator wants to know what is going on here,
Yeah, right.
You want to be the one who has the credibility, not only in your own client's interest, but also in the interest of the overall mediation, making a deal for everybody. You want to be the one to whom the mediator can turn.
I think that's exactly right. And I can think of one mediation, the day went very poorly, but I knew it was a good sign when the last hour or so, the mediator was sitting in our room, just saying, okay, walk me through what's happening in that other room. Like, I don't understand why they're doing what they're doing. Can you explain it to me? And then, one thing that I did want to mention as we talk about, both sides of the mediation is what we did in that last session, where the mediator knew that he trusted our room. He knew that it was dysfunctional in the other room, and it literally was. And he said, well, what can we get out of today that is going to help you when you go back to this judge? So for that one, we walked out with stipulations as to the numbers at issue. And, where he said, I want you to get something to bring back to the judge so that you can say you were successful, that you were here in good faith. Let's see what we can do. That case did not settle afterwards, but we still got something out of the mediation. And it was because the mediator had gotten to the point where he says, all right, you all are shooting me straight. Let's see if we can get something that is going to make the ride easier from here on out for you.
Well, this is interesting because earlier you used the term failed mediation, and I got the sense that you were using it synonymously with did not settle. And yet here you're offering what I think is perhaps a more subtle idea
Yeah.
of what success is in mediation. Can you comment on that a little more
Yep.
broadly?
No, I think that's exactly right. I mean, there are some cases, and that one I'm talking about, we were ordered to mediation. There was no choice. You We did not think it would settle, but you kind of get your hopes up leading into mediation anyway. You're like, we're going to mediation, we're all traveling across the country, maybe something magical will happen. It didn't, but we walked out with something that was useful in the case and expedited the resolution, right? It probably shaved 6 to 9 months off the litigation by coming to agreement on numbers, and let's just move forward and we can take the thing up um, on appeal when we lose. And I think there's also, failed mediation days where there is just something went wrong. There was a disconnect in the numbers. And that is where I do think really good mediators can help as well, to say, all right, people are out of authority today. There's some disconnect. I'm going to send you out with these tasks. I want you to go explain to the other side how you got to this number. And then in 2 weeks, let's have the lawyers get back on the phone for 15 minutes and see if there's something we can do. Sometimes the mediations set up conversations between the lawyers, right? That we had at least got far enough that the lawyers can carry it on and say, let's get to a resolution, even if the mediator isn't the one facilitating those, follow-up discussions. But oftentimes, again, because after a failed mediation, people are even less interested in being the one that shows weakness and calls again. To have the mediator say, I was just following up. It's been 2 weeks to that mediation. Do you think it's worth me calling the other side? That is a gift oftentimes. I mean, I'll tell them if the answer is no, right? And say, no, we're perfectly satisfied with where we are. Don't even bother. But in other circumstances, I'll say, yeah, call them and just see if they have another number. I'll bring it back to my client. I think tempers have lowered enough that we can do that.
What are other components of appropriate or good best practice follow-up by mediators in situations where a case hasn't settled?
Well, I do think the follow-up, just sort of, even without you asking for it, just to say, let me check in 2 weeks later and see what's going on. Not to try to sell your services, just to say, like, let's just see if we can get this off your docket if you think it needs to get off the docket. I have not had that many mediators send surveys afterwards, but I think that would be interesting. It probably would, if I were a mediator, that might be something interesting to do, to say what worked, what didn't work, why didn't it settle? If you can reveal that to me, was there anything, that we could have done that day to make it work better? I think that would be an interesting, and there are, certain situations I've had where we know exactly when in the day things went wrong. Not that it's necessarily the mediator's fault. I mean, it could just be one side or the other, but to be able to share that, probably for the mediator to stick in their learning bank of, okay, here's one more example of something that I can learn about how the dynamics of mediation work.
Mm-hmm. So I assume you mentioned mediators not using this to try to drum up more business. I assume that you would not take well a mediator charging you for what are in essence unsolicited phone calls.
It kind of depends. I mean, I think if we re-engage in real mediation, I have no problem paying a mediator by the hour to get it done. I mean, if that's that, if they're spending time shuttling back and forth, as long as it was clear up front that the fee was for that mediation day, and extra amounts if you want to re-engage me are going to be, by the hour, I wouldn't have any trouble recommending that to a client, because otherwise they're paying me to try to accomplish that.
Mm-hmm. Okay, we've got just a couple minutes
Okay.
left. I want to make sure that you have an opportunity to we got a bunch of mediators who are listening to this, and there will be many more watching the recording of it. If there are words of wisdom that you want to share that you haven't had a chance to share yet, please illuminate us.
I don't think there's any other words of wisdom. I love the area of mediation. Hopefully, I will get to do it at one point too. And that's on my list of to-dos. Now that I am past, I get to hopefully get trained. I just think it's something that we should be using in litigation and not have it be a sign of weakness. It doesn't, I mean, litigation is very expensive. Business disputes are expensive. A lot of other disputes are very expensive. The court system is overburdened. So just kind of keep at it and say, let's find ways to work it into scheduling orders early so that you can have a consideration of resolution. So you don't have the inevitable conversation of, well, if I ask for mediation, it's going to be a sign of weakness. Advocate for having that more present. And then I'm going to do my part to keep looking for diverse mediators and being sure that we're having our mediators reflect who our litigants are.
All sounds good. Jean, do you have any words of wisdom you'd like to share, or any quick questions?
Well, I loved hearing all of your comments. Thank you so much, Anne Marie. I thought the ones you were talking about where there's multiple parties involved were especially apropos, because so often that is the case. And whether it's multiple defendants, multiple plaintiffs, it's not always easy. That, and then the actually pre-mediation sessions as opposed to just phone calls. That's I think a helpful suggestion to people. I don't know if you'd have anything more to comment on any of those.
Yeah, I think that our switch to Zoom has allowed that the opportunity for pre-mediation. I can't recall doing it as often when we were doing only in-person mediations. But now I find that even if we're traveling for the mediation, mediators are finding it easier to offer a pre-mediation session. And I would definitely, encourage that as well.
Yeah, Zoom has changed our lives.
It has, for better and worse.
Yeah, that it has.
As demonstrated by the fact that here we are right now at this very moment, right?
Right, exactly.
All over the country and perhaps all over the world will be watching this. Well, this has been a tremendous program, very educational, I believe, for mediators and advocates and clients, as well as to how to get the most out of the process. So Anne Marie Seibel, thank you so much for this. We encourage people, if they're in a position to do so, to support the Community Food Bank of Alabama. And the website for that is https://feedingal.org. That's https://feedingal.org. Anne Marie Seibel, thank you very much for this very educational hour. Jean, Natalie, our audience, thank you as well. And with that, we are complete.
Thank you for the invitation. Have a great day.
Thank